So, good afternoon, welcome everyone. This is our second part for the colloquy for week 7. We're doing it in Springfield, and today we're going to continue on chapter 12 from duress, which is of course from page 316. We're going to cover the rest of it, and then we're going to go on and cover chapter 13. All right. So far, we said that we are dealing with the analytical structure for simple contracts. So back from chapter 7, we said that there are two steps or two analytical structures you need to go through in order for you to ascertain whether there's a contract, so there's a contract exists, and then whether that contract is valid. So, let's go back and just remind ourselves of that. So, page 193. Page 193. Okay, sorry about this. Here we go. So, just to emphasize that I've given you a handout that you will find very useful for exam purposes. So just make sure that you familiarize yourself with that, and I will take you through it myself actually after the break when we look at examples of previous exam questions from part B. And the idea there is that you need to look, if a question comes under contracts, and there will be one, you need to look at the existence of a simple contract. And we said it's not a matter of saying yes or no. We have to ask ourselves whether there's an agreement, whether that agreement, whether there's intention to create legal relationships, and whether there's consideration. If you fail on any of these, just a flow chart. If you fail, then you wouldn't be able to make this cause of action, so you wouldn't be able to bring it to courts. Okay? If you do, of course, you will lose. On Monday, we started working on the next phase of this analysis. So we said if we succeed and there's an apparent simple contract, the next step then is to test its validity. Okay, so that's what you will see on page 194. So we have to continue looking at the capacity of the parties to contract. So we looked at people like, for example, infants, people that are mentally ill, people that are intoxicated, and so on. Corporations, bankruptcy. Okay, so those are people with limited capacity to contract. Okay, not corporations, but that would affect the validity of the contract because it goes back and puts a question mark around the agreement. Okay, especially when we looked at consent in terms of mistake. Okay, so on Monday we talked about mistake, and we said some mistakes, okay, would render the contract void, simply because based on that mistake we would see that there is no consensus ad idem, or the fact that there is no agreement. So the first element, agreement, actually doesn't exist, and we will know this only afterwards. So that will tell us that the contract is void ab initio. Okay, mistake is a very complex area, but we said in general, if you have a mutual mistake, or you would have a unilateral mistake, or you have something that would solicit the defense of non est factum, all those things would mean that more likely than not there is no agreement, and hence the contract is more likely than not to be void. Sometimes it would be voidable, but it's going to be void. So we're going to continue today the same analysis on this idea of consent, but we're not going to focus as much on whether an agreement exists or not. We're going to focus on whether the agreement is voluntary. So was the agreement between the parties created involuntarily? So there was some problem, for example, in terms of forcing the other party to enter the contract. That doesn't mean that we don't have an agreement. The agreement exists. So this analysis I'm going to talk about today will simply say that the contract would be voidable. So let's start then with this idea, legal theory of duress. And it really talks about something very similar to what we saw with assault. You know? Remember when we talked about assault in terms of violence or even threats? This is the same thing. But the intention is not to steal, for example, or because there's some sort of an altercation between the parties, but you are trying to get them to do something, basically enter into contract. Okay? So you could either threat their person, or threat their goods, or it could be a threat to economic interests. You know? Whatever forces this person to accept the contract. Okay? So as we said, the problem here, we have an agreement, but the agreement is defective in the sense that it is not voluntary, it's involuntary. Okay? So how is that going to affect the contract? You still have an agreement, but it's defective. So it becomes voidable. And do we know what voidable means? If not, you can go back and check on page 100, I think 95. Yes? So it will tell you exactly what we mean by voidable. In a nutshell, we have a contract still, but out of equity, out of fairness, we're going to give this person, the person that was forced to get into the contract, we're going to give them this option. They can elect to get out of this contract. They can have the option of terminating the contract. So the key point, again, is the lack of voluntary agreement. It's a lack of voluntary agreement. Just to make sure everybody is with us. So the people online, please let me know if you can't see something. Just let us know. So again, the problem here is not that we don't have an agreement like we do under mistake, which would make the contract void, i.e. it doesn't exist. Here we still have an agreement, but there's a problem with the agreement. So it will make the contract only voidable. All right. So we said there are different types to duress. I don't want to dwell too much on this, but you can have duress targeted, so threats and violence targeted to a person. Okay? So threatened violence to one contracting party, immediate family, or on behalf of the other contracting party. What do you need to do to establish that there is such duress? Hi, is there someone online that needs to mute or wants to say something? Okay. And Andrea, you need to mute. I'll go ahead and do that for you. All right. So what we need to do is to look at, again, the elements. So I think law, I was reading a paper from CQU, Central Queensland, and they went through a research project to see whether using our analytical structures, i.e. law analytical structures, would be useful for non-law students like yourselves. And so basically, it was encouraging to see that students thought that it's a good idea to use things like ILAC or things like what I'm teaching here, Wentworth Miller, the ERC, because what it's telling you is that everything goes through the same analytical structure. You always talk about elements. Now, what's the problem? You need to find the elements. Okay? So that's where your notes will come in. And I've given you enough notes, I hope, but it's a template. It's a Word document. You can add to it as much as you want. There's no limit. You can take 100 pages of notes if you want, but just remember that you have only 2 hours for this exam. I proposed to have an open book, open time exam, or an open book, which we do in law schools, at least where I graduated, because you're going to fail anyway. Seriously. Or you can have open book take-home exam. So you can just have it and then come back the next day. But that's not happening in this institution yet. We're going there, hopefully. So you need 3 factors. They call them factors. They're not factors. They are elements. So you need to prove that this threat or this violence, okay, operated to interfere with your free will, free exercise of a coerced party's will. Okay, so that's a fundamental assumption in contract theory, that the parties are entering into an agreement, by their own volition. And that's the second one. The duress prevented this party or the parties from meeting and negotiating on equal terms. You saw this thing or this argument again in your assignment, that we said sometimes, for example, an ADR-like negotiation would not work if you have unequal negotiating powers. So if you find someone like a customer who wants to negotiate with someone like a company, there's a big difference in their power, which means that the negotiation is not going to work. That's exactly the same calculus or same dynamic that's taking place here. So we're saying one party is so strong that they are threatening or actually carrying out violence against the person or the goods or the economic interests of the other part of this contract to make them come into the negotiation and agree on the outcome, i.e. the agreement and the contract. So that's the second thing we need to prove. And then as a result of the duress, so once we have proved that there was duress, so what? The mind of the coerced party didn't go to the transaction. So this coerced party never accepted to be part of this contract. They had to go along with it simply because of that threat or that pressure. So that's what you need to look at if you get an exam question or a situation where you want to gauge whether this is something that has to do with duress and whether I need to actually, bring it to someone, even the police, for example. So before you waste your time, it's worth looking at this so that you can see whether something the police would be interested in or not. By the way, one of your colleagues started actually a discussion on the forum. And I put up some answers there and I said, we are going to have the same sort of approach when it comes to discussing part A exam questions. I will take you through some of the previous exam questions, but I'm not going to do it here. It's going to be online. So I will be posting these questions and taking you through the discussion, not necessarily answering the question for you, but hopefully eliminating some of these options. So you have 4 options. Maybe we can make it 50-50. So we can always knock off 2, leave you with 2, and hopefully you will pick the right one. So it's important for you to go on this forum and check, what's going on and what I'm doing there. All right. The second type of duress is targeted to goods. Okay, it's targeted to goods. So here you have the coerced party would have to show that the coercing party used extreme pressure. Okay, thus leaving no real alternative for the coerced party but to submit. An example, they come to you and say, we're going to burn your business. And put them out of business if they didn't agree to enter into a contract. Is this far-fetched? Have you heard stuff like this before? Have you seen something like this? Do you know of any real examples of that?
Can't think of any.
No?
I can't think of any, but I'd assume that during people's prohibition era, technically would have been like it there with say gangs, like organised crime gangs would have threatened to burn a business down if they didn't agree to a contract. And then you could even say that there has been fires at nightclubs in Sydney and stuff like that, where they suspected foul play was involved. and that there could be the exact situation there, but as I can't confirm it, it's not.
So, yes?
Acid in the lubricant dispensers.
Acid in the lubricant dispensers. Yeah, that's one of the things that you're saying happened to someone.
Oh,
Yes.
oh,
Yeah.
and they have lubricant dispensers in nightclubs these days?
In those kinds of.
Oh, those.
Yes. Yeah.
Excellent, excellent. Any other examples? We've all heard about things like the mafia, for example. Do we have mafia in Australia?
Oh, we have Greek ones, I think.
Freak ones? Okay. Greek ones? Okay.
Not from
Any other nationality you want to insult?
Italians.
Italians?
Well,
Yeah.
they're the-
Jewish? No? All right. Okay. Anyone from this side, because I always neglect you? So we're saying, is this something that used to happen in the 20th century? It never happens anymore? It does, but what? What's the difference? It's more subtle these days. Okay, it's done a little bit more indirectly, rather than going through the mafia kind of approach where you are confronting people, but it actually still happens. And here's another one. This is the third type. Probably this is the most prevalent today, and that's economic loss. How does it work? So, to succeed in this action, it would be necessary for you to do the following. Two things. You need to prove the pressure was one of the reasons the coerced party entered into the contract. Okay. And the pressure was such that it was beyond what could be accepted as reasonable commercial practice. Okay? For example, unlawful threats or unconscionable conduct. Okay? Now we're going to unpack this unconscionable conduct a bit more because it's actually a separate cause of action. Okay? So overwhelming pressure not amounting to unlawful threats or unconscionable conduct will not necessarily constitute economic duress. All right. We'll come back and look at some of the cases as well in our textbook. Let's move on and talk about undue influence. So we finished now duress, 3 types. That's one cause of action. This is a different one, different theory. Undue influence. What do you need? Again, improper use of a position of influence or power. Okay? That one person has over another to induce that other person, the coerced person basically, to get into or to act for the former's benefit. Same thing as with duress and everything I'm going to discuss today. It's all about fairness. So at best, it's going to be voidable. The contract is going to be voidable in the sense that the injured party or coerced party has the right or the option to go to courts and say, I want to get out of this contract. Okay. Under undue influence, we have 2 types. Okay? It depends on whether you have a special relationship or you don't have a special relationship. Okay? The top row talks about no special relationship. Okay? Again, both contracts are going to be voidable. Okay? However, the top one talks about improper use of a position of influence or power. Here the onus is on the plaintiff to prove the defendant exercised influence. But if there is a special relationship, we switch that onus. So here unequal relationship, okay, presumed. Remember the unequal relationship? We talked about negotiation. We talked about it in duress. It comes back again here under this concept of special relationship. So unequal relationship presumed to exist between D and P, knowing that D is the defendant, P is the plaintiff, because of a parental or confidential relationship. So here the onus would be on the defendant to prove that the transaction was voluntary and that P understood the contract. Okay? We'll look at examples to flesh this out as well. All right, this is the third theory or cause of action that we call unconscionable conduct, which means that it's unfair. Okay? Unfair. So it's all about equitable theories. Okay? Remember, these are all under the court's discretion. Again, you must prove the following. 4 things. First, they were in a position of special disadvantage. So the injured party, the movement, the one who's going to court, has to show that they were in a position of special disadvantage. That it must have substantially affected their ability rather to protect themselves, this special disadvantage, and that the person, the defendant, okay, the person who took advantage of this party must have known, so this is actual knowledge, or should have known, which is what we call constructive knowledge. So when we say should have known, you immediately see that we're talking about an objective theory of law. So it attracts the reasonable person test. So a reasonable person should have known of the plaintiff's disability and has taken advantage of it. And the last thing is that the actions were unconscionable, i.e. unfair. So it's really a policy consideration, or value judgment, if you like. Okay. So let's continue a bit with unconscionable conduct, and we're going to look at what is unconscionable conduct under CL. What is CL? No. For the love of God. This is week 7. Common law. Thank you. So K stands for a contract. Okay? Not capital. K stands for contract. Okay? CL stands for common law. Use these in your answers in the exam, please, so that you can write more. Not because writing more is going to get you more marks, but because you can manage your time better. All right. So the first thing is that transaction is unconscionable, okay, when there has been an abuse by the defendant of their superior bargaining position. So it's the same line of thinking, whether we talked about negotiation as an ADR, or we talked about it in duress, or now we talk about unconscionable conduct. You see that it's always about this relationship between the parties and whether there is a David and Goliath kind of situation. Okay? So that's when equitable jurisdiction kicks in to make sure that things are fair. Okay? If the facts show that the conduct of the defendant was such that it is, in fact, so let's do it one more time. If the facts show that the conduct of the defendant was such that it is, in its rather factual setting, fairness and good faith, if the facts show that the conduct of the defendant was such that in its factual setting, fairness and good faith could properly be expected to be exercised, and it can be shown that they were not, then these conduct may be described as unconscionable. So they're telling you this is a question of fact. You have to look at the facts, okay, the factual matrix, and each case will depend on those facts. All right. Now, unconscionability also attracts the ACL. What is the ACL?
Australian consumer law.
Thank you. Australian consumer law. Where do you find Australian consumer law? In Schedule 2 on the internet, absolutely, but it's part of the 2010 Commonwealth Act that we call what? Competition and Consumer Act. Yes, I think it's CCA, Competition and Consumer Act of 2010. That's Schedule 2. It's called the ACL. So in terms of the ACL, I don't expect you to go and look at it online. I don't expect you to go and look at it in a way that I'm doing, these slides in terms of the classical contract theory. But I still expect you to weave it into your answer when you get a question about contracts in the exam, if that's relevant. Okay? So all you need to do is to look at just some of the sections. So this boils down to this. In your notes, make sure that you have at least one page on the ACL. So things like what? There's also another one called the ASIC Act. Okay, they both prohibit unconscionable conduct within the unwritten law. So current case law applying the principle of Amadio. We'll look at Amadio. So you'll find Amadio reflected in these cases, in these acts under these sections. And you have remedies that include things like injunctions, damages, okay, disciplinary ancillary orders, non-punitive orders, and adverse publicity orders. Okay. Again, ideally, yeah, we can spend the whole month talking about the ACL. For our purposes, yeah, just flesh out what you have on page 223. Just make sure that you flesh that a bit and put it in your notes. All right. Okay, so let's move on then to the next chapter, which is chapter 13. And this is what we talk about in terms of the sixth step of our analytical structure. Okay, so this is what we call illegality. If a contract is illegal, step 6, if the contract is illegal, okay, then more likely than not it's going to be unenforceable. Okay, I enter into contract with a person to buy and sell drugs. Okay, you really think any of those parties is going to take this to the court and say, you know, I want my money or I want the drugs? Okay. So that's what I mean by it's unenforceable. You can't go to courts on that. However, there are two types of illegality. Okay. So the first one is illegal as formed, and there's illegal as performed. Okay. So as you can see, if the contract is illegal, especially if it's illegal by statute, so you can find a piece of legislation that says this kind of contract is illegal, then of course it's void by that statute. Okay. And there are, as I said, two types. It could be illegal as formed or illegal as performed. If it's as formed, okay, this means this should have never been entered into. For example, a contract for selling drugs. However, sometimes the contract could become illegal as performed. For example, okay, well, I'm giving an example here, but you might enter into contract for the construction of a certain type of a building, okay, and while you're doing that, maybe the local council would pass something like a bylaw, or what they call local laws now, where they decide that that kind of building, maybe because of the number of stories that you are building, or the foundation you're using, or even sometimes because of the cladding that you have, which could actually be, you know, a fire risk, sorry, could be flammable or a fire risk, then that becomes illegal as performed. You started, there was nothing wrong. Later on, something kicked in, so it became illegal. So he would say, okay, it's not necessarily illegal and enforceable. Okay, so if innocent conduct is incidental to performance. Okay, we'll look at some examples, see how that works. Now there are also the contracts that are void by statute will not be enforceable by the courts, like for example selling drugs, and create no enforceable rights between the parties. All right. So in what ways may a contract be illegal under statute? Okay. So it could either be, so we're just again talking about what we just said, illegal as formed, because it's forbidden by that statute. Okay. Like a license, you need a license for it. If you don't have a license, then that becomes an illegal statute. Or illegal as performed. So here's an example of a taxi driver, okay, carrying more than the licensed number of passengers. So you got the license, okay, everything's great, but then you went and did something that the license wouldn't actually permit, and that means that you became, that act in itself is illegal, but it's illegal as performed. So let's look at, we talked about statutes, let's look at the common law. What's the difference between contracts that are illegal at common law and those that are void at common law? Again, illegal contracts, violate social or moral attitudes. So common law would say if you have a contract that's violating social or moral attitudes, that would be illegal. Examples: committing a crime or a tort, or the promotion of corruption. We'll look at an example. Or it could be the contract is void because it's a matter of a public policy. The example given here: contracts that prejudice the status of marriage. So these are very old cases. The ousting of the jurisdiction of the courts. So you want to write a contract where there's a clause that says you cannot go to courts. Or are restraint of trade examples, and we will look at one of the restraint of trade examples. Of course, today you can write a contract with a clause that says, for example, that we will go to arbitration, like an employment contract that says that we will go to arbitration instead of going to court. That's not ousting the jurisdiction. That's something legal. Okay, but we're talking about common law, so this is more like a historical sort of example. Today you can, of course, in certain situations, oust the jurisdiction of the courts, at least to the point where you have to go to arbitration first, and then, if that fails, you go to courts. All right. So as I said, what I want to focus on is this idea of restraint of trade. What is the effect of a clause in a contract in restraint of trade, and what circumstances will be legally enforceable? Again, and it's one thing that if you can just leave this course with, hopefully you will do fine, this idea of reasonableness. Okay? The whole thing really turns on whether this restraint of trade clause is reasonable or not. And the reasonableness goes through three dimensions. So there is the geographical extent. So if I put a restraint of trade on you, so I take you in and teach your trade, okay? Or it's an apprenticeship for you to become a lawyer. Okay? Once you get that done, I might actually say something in the contract that I will restrain you from competing with me because you can now offer the same service I do on a certain geographical extent. So maybe let's say the Darling Downs, or Southern Queensland, or Australia, or Earth. And you can see how reasonableness starts kicking in. Okay? That's the first dimension. The second one is the time period. I will restrain you for 1 year, 1 decade, 1 century, 1 millennium, and so on. And so I'm trying to get you to think about reasonableness, how that actually becomes reasonable or unreasonable. The third dimension is the type of the activity. So am I restraining you from doing everything that I do, or certain sort of boutique kind of services, and so on and so forth? We'll look at examples. This is what I want to focus on in this chapter. What is the effect of a clause in a contract in restraint of trade? So if there is a restraint of trade clause in the contract, so what? And in what circumstances will it be legally enforceable? We're talking about, again, in the case of restraint clauses in a contract of employment, just like what we talked about, the restraint must be reasonable. Okay? In the case of a vendor of a business, so you're selling a business, not just employment, but I'm trying to sell you a certain business, and I'm afraid that once I sell you, for example, my law firm, I'm just going to go and open another one down the road. That kind of situation. It's assumed that the parties are in an equal bargaining position. So that makes it harder for you to prove that I'm the coerced or injured party. And then you'd ask, what's reasonable in the circumstances? All right, let's go back then and do some cases. Just a few. So let's start from chapter 12, from duress. So we're talking 316, page 316. Let's go to page 319, and we're going to look at universe tankships. So, the case is from the UK from 1983. The Universe Sentinel was owned by the plaintiff company. You know what Sentinel means? Anyone?
Some sort of hunter or something.
Some sort of a
Hunter.
hunter? Yeah. Guardian? Something like maybe a guardian?
Yeah.
There's a movie by that title, Sentinel, the Sentinel.
The term sentinel used.
What does Sentinel mean? Anyone online that can check what Sentinel means for us? So if you don't understand something, just shout. Tell us that you don't know it.
A person or thing that watches or stands as it were.
Yeah, something like a guardian. Yeah. Okay? So, the Universe Sentinel, what would you call it, the Universe Sentinel? Okay? Was owned by the plaintiff company. We're talking about tank ships. After unloading its cargo in Wales, the ship was subject to a ban by the defendant. Okay? The financial sequences or consequences of the ban were such that the plaintiff agreed in writing to the defendant's demand, here we go, to pay money into its welfare fund if it wanted the ship released. Okay? So that's what you would be doing, of course, when you were doing your exam with a highlighter, because this is where it all starts. So there was a ban on this ship, and the ban meant that there would be financial consequences on the plaintiff who owns the ship. So they decided to agree to a payment of money. Agree money, so there is a contractual relationship. Into this welfare fund, okay, in order for the defendant to release the ship, which is the Universe Sentinel. So the ship was released. As you'd expect, the plaintiff sought to have this contract declared void. Why would you want to do that? Because you don't want to pay the money. And to recover, or actually they have paid already, so now they want to recover the money paid under the contract. If it's declared void, then that means there is no contract, which means that why would this person, the defendant, keep that money? So you want that money back. So the question here, and as we always say, this is the legal issue. So when you are going to go to the exam, okay, and I'm going to make sure that the markers look for that. If you don't show the legal issue, you're not going to pass that part. You need the legal issue up there. Now you can express the legal issue in so many ways. But remember that the legal issue has to be there. It's going to be only one. We'll have many legal issues per question. Okay? Here the legal issue was, this was the fear of economic ruin. So we're talking what? Economic duress. Beyond what the law would countenance as a legitimate commercial tactic. Why is this the legal issue, you think? Well, let's go back and check what we said about this type of duress. So we looked at it as economic. Okay. So we said in order for us to argue economic duress, you need what? You need two factors, or two elements. We said you have to prove that the pressure was one of the reasons the coerced party entered in the contract, and the pressure was such that it was beyond what could be acceptable as a reasonable commercial practice. That's what they're talking about here. That's how you came up with this formulation for this legal issue. So you see that they're talking about legitimate commercial tactic. That's where this is coming from. Okay? So they looked at both of those elements, and they decided that the first element is not going to cause any issues because it's obvious on the facts, but the second element might be the legal issue. So you know how you do the legal issues now? So you decided there's something here about an economic loss, economic duress, in the sense of what? Financial revenues because the ship is not making money anymore. It's just held hostage by the defendant. So this is economic duress. What are the elements of economic duress? And then what is the legal issue? So you look at the first element on the facts. Is there a problem? Here they're saying there is no problem, and I would agree, because on the facts you can see that there's a ship. The ship is not making any money anymore because it's now embargoed basically by the defendant. All right? So you come to the next element. Is there a legal issue there? So how do you decide? So you have to go back and look at this legitimate commercial conduct. So here there is tension. Is that legitimate commercial conduct? If someone unloads their cargo on whales, and what was the reason for them to actually hold the ship and then force you or require you to pay into a welfare fund? Is that actually something that has to do with commercial custom? Okay. What did they decide? This was the House of Lords. It said the defendant didn't dispute that its actions amounted to economic duress. So they said, we'll give you that. Are you following what's happening in the High Court under Section 44 in relation to the citizenship of our parliament, members of parliaments? There are 7 people involved. You know what's going on there, the saga? So you'll find they use the same tactic. At least Barnaby Joyce, and the other Italian one, can't remember his name. Yeah. They said, we agree. We have dual citizenship. That's not the issue. Okay, the same tactic. Let's not waste our time saying we had economic duress or not. So we will give you the issue. The answer to the issue is yes. So there is economic duress. But what? Okay. So the defendants didn't dispute that its actions amounted to economic duress. The contract was void, and the plaintiff was entitled to its money back. Of course, that doesn't really tell us why. Okay? Why the defendant in this case gave away this chip? Why would you go in and say, I agree, there's economic duress? Because that's the end of it. You have to give the money back. In our case, in Section 4, it's not our case, in Section 44 with the HCA, okay, the High Court of Australia, they have a different tactic. Why do you think they went in with that argument? Why would you give the court from the beginning saying, yes, we violated Section 44, subsection 1? Why? Why would you do that? Are you paying for the costs? No, you're not. So why would you do that? So I keep telling you about law and economics. Yes?
There's probably other factors in there.
Yeah, I know.
So the thing is, that if they are, then, and they say, oh, we're not things, and they'll be lying in front of a court.
What's happening in Parliament at the moment?
What's the name?
Are they sitting? Is the Parliament sitting at the moment? Are they in a recess?
They're in a bit of a break, aren't they?
Okay, there's a break. And when is the break going to end? Soon? So sometime in September? So that's my point. What they're trying to do is to push the High Court to come out with a decision quickly. So don't waste time talking about, yes, we have breached Section 44.1. Sorry. The argument was that we already have dual citizenship. So don't worry about establishing whether we have dual citizenship. I just want you to tell me whether on your interpretation we have breached Section 44.1 or not. So you'll notice that even though we have 7 members of Parliament, it has nothing to do with what we're doing here. But you'll find that some of them come through descent. Okay? So it's not them actually who were born, for example, in New Zealand. It's their father who was born in New Zealand. And whether that's something that the High Court should actually take into consideration as distinguishing between people who have violated the section or not. Coming back to this. So again it says in the comment, essentially economic duress is about the unconscionable conduct of the stronger party. Okay? There must be pressure by the stronger party, the practical effect of which is that the coerced party will feel that they have no practical option but to agree. Okay? So the key point again is always going to be how to ascertain what is legitimate business pressure. Remember, business is all about pressure. Okay? So when you look at someone like Donald Trump, And people go and say, oh, this guy is cuckoo. Actually, because that's how they conduct business. And that's legitimate. But that kind of pressure is not legitimate in a political sense. Okay? So always, business is going to be about trying to squeeze as much as you can out of the other party. It's about your bottom line. It's about your profits. So always think about this kind of situation if you get a question in the exam about economic duress. All right. So let's move on to page 321. And I'm going to look at unconscionable contracts and Amadio, because Amadio is really the flagship case in this area. So we need to look at it. So, here we go. So, this Amadio from 1983, again on page 221. So this is in Australia now. An elderly Italian couple with little understanding of written English or formal education signed a guarantee and a mortgage over a block of shops to the commercial bank as security for payments of debts, okay, of one of their sons' companies. So the son went to this bank, I want a loan, yes, we need a collateral, okay, the collateral is from my mom and my dad, okay. And they said, yes, we're going to sign off and we'll give you the collateral. Their son was a property developer and builder. Okay. At the time of signing, these couple were led to believe by their son that this guarantee was up to 50,000 and limited to 6 months. So there's this guarantee and a mortgage, and the son said it's just for 6 months, it's just up to 50,000. Okay? Now what are they putting up for security? A block of shops, okay, which means that it's definitely going to be higher in value than 50,000. They thought that this is not a big deal. 6 months, 50,000, it's all right. We will guarantee it. The son also told his parents that the company, his company, was in a good financial situation. Okay? When in fact was in serious financial trouble. Okay? When the bank manager, so now they brought the papers to these folks at their home, the Amadios, okay? He corrected their misunderstanding about the length of time this guarantee is going to take, okay? And explaining that it was for an unlimited time and not 6 months. However, the manager didn't explain the possible effect of the documents, which the Amadio couldn't read. So, the manager also did not mention the fact that the amount was unlimited. Okay? So, the son is telling his parents, it's just 50,000, just for 6 months. The bank manager said to them, it's not going to be for 6 months, it's unlimited. But there was something else unlimited, which he didn't mention. And they don't know how to read English. When the son's company again went into liquidation, as you'd expect, the bank attempted to exercise its rights, so they attempted to have the contract set aside. Okay? So who are the parties here?
Bank.
The bank moving against Amadios, and Amadios moving against the bank in terms of trying to set this contract aside. When you say set the contract aside, they're trying to get the court to declare the contract what?
Invalid.
No, void. Okay, it's similar. It's similar. Invalid is fine. Okay. All right? So what was the legal issue here? So they said, was the conduct of the bank such that it could be regarded as unconscionable? What did we mean unconscionable means? Another word? Unfair. Unfair. Okay? Unfair. So you write unfair, that's fine. That is, had the bank taken unfair advantage of its superior bargaining position for its own commercial gain. Okay? So, the High Court, this was from the High Court, it said a court in exercising its equitable jurisdiction could set aside a transaction if it was unconscionable. Okay? The bank was in a superior bargaining position. So the minute you hear that, you know that it's not good if you are representing the bank. The bank was in a superior bargaining position to the Amadios. Why? Because it knew both the financial position of the son, so it knew that there was a problem with this company, and that his parents didn't fully understand what they were entering into. Okay? So they established that there was a special advantage. Why is this important? Why would you want to establish a special advantage? Where are they going with this? Well, they're going with the elements. Remember the elements? So we said we need to establish the following in order for us to establish unconscionable conduct. The summary for this case is not going to take you systematically like in engineering or under mathematics, or if you are a computer programmer, it's not going to take you through the steps every time because it's boring, right? So they're going to just talk. Your job then is to see why they're talking what they're talking. So you can see that we have to look at this idea of special disadvantage. So this part here. Well, okay. This part here. Okay? That's why you see that when we go to this case, you see that they're talking about this special disadvantage. This is where it's coming from. Okay? So every time you want to answer a question, don't just start writing. Always go back and look at the elements and then decide whether one or more of these elements creates an issue in this factual scenario. So you can see that they formulated this issue here as a broad issue. They just said whether there was unconscionable conduct or unconscionable behavior. And that's perfectly fine. So in the exam, if you want to write your issue as a broad issue, that's fine. You want to narrow it down because you see that most of these elements you don't have to talk about, that's also fine. Here's what you need to do. If you're going to take a wide approach, then that explains to us that you're going to go through each and every element. At least you're going to say something about the element. Okay? Until you say that this element is the issue. You'll have to narrow it down later on. So it's fine to phrase it this way, but later on in the application, you have to tell us which really one of those four elements is the issue here. Okay. So here's how they narrow it down. The parents were in fact in a position of special disadvantage. Why? Because they didn't understand the extent of their liability under the agreement. Nor did they understand the financial position of their son's company, which was being propped up by the bank. Essentially, there was an abuse by the bank of its superior bargaining position in its dealings with the Amadios. Okay. I hope that you understand when they say the test, okay, that means the legal test you need to apply based on those elements to find out whether you can make this cause of action or not. So they said here, the test for this theory, unconscionable conduct, is by reference to this special disability, special disadvantage, which may disadvantage a weaker party in a transaction with the focus on the exploitation of the weaker party. All right. What about this part here? So, if we want to use this as one of our exam questions, we're asked to reflect on this. Would the conduct of this bank still be unconscionable, which was in this case, if we change the scenario, so the counterfactual, and say that in this scenario, what happened was that when the bank went to their home, so we say here that, what did they say? The bank was, sorry. So here, when the bank manager brought the papers to their home, okay, let's then extend this now and say they advised them, okay, they advised them to seek legal advice. However, after the manager left the Amadios, the son convinced his parents that that would be unnecessary. Okay? Something like that will have to force you now not to simply say that, oh, Amadio says that this is unconscionable, so it's unconscionable. So we're going to play with this fact and see what you're going to say. Okay? That's the same thing we're going to do. That's the game we're going to play, hopefully, in October. All right. Let's look at another special disadvantage on page 222. This is from 1992. Luth and Diprose. Okay. It's a love story. Diprose fell in love and became infatuated with Luth. Okay. But this was one of those things you call unrequited love. Okay? Because Luth didn't have similar feelings towards him. Luth falsely told Diprose that she and her two children are in trouble. They're going to be evicted from the house they occupied. You're too young probably to understand what we're talking about here, but hopefully later in life you will know what's going on. Okay? Diprose gave her money to buy a house in her own name. The power of love. The issue, was Diprose under a special disadvantage? The power of love. You see the power of the bank against Amadio? Was Diprose, this is emotions now, right? Was Diprose, how is the code now? Let's see. Was Diprose under a special disadvantage in the sense that Luth had exploited his feelings for her, okay, and manipulated him to her financial advantage? Or was this a case of imprudent gift? What's the difference between a gift and a contract?
Gift has no strings attached.
Okay. Do you have to, so do you have to have elements like agreement or intention to create a legal relationship or consideration for that matter? Do you have to pay a price for the gift? No. It's imprudent, of course, because why? Because he's under her spell. It's Italian, right? But they don't say they're Italian. It's just like the Amadios. There's Italian into it, right? This love and like the Pastor Sus ad, that old woman, love, you know. Luther's conduct was unconscionable. Okay, so they said you can make the cause of action. It's not a gift. Why? And the court ordered that ownership of the house be transferred back to Diprose. Thank God. Otherwise, imagine how much he would lose on the house. What is the house worth? This was what, 1983 was it? 1992? So, 300, 500? Now look, there was a dissenting judge. The majority considered that Diprose was under special disability, the power of love, or special disadvantage, because of his infatuation with Luth and his consequent extraordinary vulnerability. I'm not saying that he's Italian, but do you think he's Italian? I don't know. This is very beautiful. A man under such power of love. In other words, are you buying into this really? So in other words, infatuation led to vulnerability in the form of emotional dependence. What are we talking about? High Court of Australia. Okay, it's all right. So it's okay sometimes to disagree with the High Court. This is like a soap opera or something. What is this? I mean, I can understand a bank, a manager, old couple. Yes. What is this? Where are you going with that? So let's reflect. Let's do our reflection, please. Do you think that if the roles had been reversed, ouch, and Luth was infatuated with Diprose, the court would have arrived at the same decision? So it's Luth, who's a very rich old woman, maybe, and it's Diprose who's with the two children, maybe divorced. So the male, Diprose, is divorced with two children, and then Luth is infatuated, by him because of whatever, and she's old, and she's looking for that power of love, and now she gives him money, or she buys this house for him. Does that change anything? Let's reverse the genders. Okay, that's the point. Instead of the male, which is usually the traditional, that's usually the male that's going to fall in love. What happens if it's the female that was falling in love and the male was just, I don't care. What if it's same sex? Yes, let's look at, what? It doesn't make a difference?
No, it shouldn't make a difference. The gift was given with the thought that the feelings were mutual.
Okay.
Which they were, which is why it wasn't legal.
All right, so someone says it doesn't matter. Male, female, it doesn't matter. What could be different here?
So we also sort of agree with his point where it's kind of like, because the person lied and said, they're going to be evicted, it was under false pretense. So they pretended they were in a sort of a situation of crisis in order to manipulate another person. It's kind of like, imagine, we're talking about catfishing, imagine getting contacted by somebody from Nigeria saying, if you don't give me money, I'm going to get thrown in jail.
I know, I'm going to die. Exactly.
Yeah.
Any other thoughts, Bill?
I'm still confused. Is Luth the one with the kids
Yeah.
saying, I'm going to be evicted, or is Diprose one with the kids saying, you're going to be evicted?
No. She is telling him the story so that she can get some, she doesn't love him. She wants something in return other than love. So that's what she did. She falsely told them they're going to be evicted.
Do we know that they actually have kids? Or are they lying and saying, we're going
No.
to be evicted?
She told Diprose that she and her two children. So please, again, in the exams, don't go inventing, okay? If I give you the facts, please stick to the facts. Unless you can infer from them, please. So, we're told, Luth falsely told Diprose that she and her two children were going to be evicted. Why? What do you want? So, because of that, he ended up buying her a house in her own name. What do you think, Bill?
I'm still a bit confused with a special disadvantage. Was a special disadvantage because of his age, or
Because of love. Because of the power of love. It's so strong that he bought her a house in her own name. What are you talking about? So if this was a situation of love, of course, you wouldn't go talking about, securing an advantage from this person, financial advantage, by lying to them, right? You would expect that? No? If there's mutual love, it wouldn't happen. But no, we're not talking about old. What other theories could you sort of invoke around Dipros rather? Now notice how the first name, by the time it arrived at the High Court, is Luth.
So he's possessive.
She is appealing. Okay, so this decision went through a number of appeals until it ended with the High Court. What were you saying, Bill?
Dipros seems to be. Oh, I just say the word. Yeah.
Like the guy in 50 Shades of Grey? In what sense? So why would you put the house? So, folks, question: why would you put the house in her name? Okay, she's going to be evicted. Why don't you just buy a house, leave the house in your name, and let them live in it, and they don't have to pay rent? Is that what you're saying?
Yeah.
And you can maybe even have visitation rights. You know. So, what do you think? Is that a better solution, maybe? You're saying yes because you just gave it to me. Anyone else?
Wouldn't that be considered harassment if he bought to give her in his name and then kept on attending? Because she could just as easily say, because she wouldn't be able to say no because it would be his house technically.
But they love each other. That's the pretense, right?
No, he doesn't. She doesn't
He
love
loves her. He's manipulative.
What?
He wouldn't know, would he? Did you know? Wait. So Bill is saying to us, Dipros knew that she didn't love him.
No.
This is very important. Did he know that she did not actually love him? Did he know that she was actually selling him this story in order for her to get a financial advantage from him?
You can assume that would be the reason why he would give her the house in her name.
But if we go with this, let's wait. If we go with this theory now, what's the problem to you now establishing that there was unconscionable conduct? Yes?
How do we know that Dipros doesn't have another form of mental condition? Or something
We
like
can entertain that for sure. Someone is saying, this guy, there's something. Okay, cuckoo. So you can go back and talk about mental illness. If there is mental illness, let's assume that that's what's happening here. We can throw in some more facts to get you to infer that this guy is crazy. Maybe we talk about something else that they have done. If they are, what happens next? If they are actually crazy, what would happen to the contract? What can you then raise if you are counseling Dipros? What would you tell him? What could they do?
Would it still not be voided whether he had mental issues or not? Once she lied to him and he bought her the house.
So someone is saying it doesn't matter. Does that make sense in your head? Someone says it doesn't matter if you are crazy or not. You're still stuck with it.
Because she said a line that was a lie and he took it, whether he wasn't in the right frame of mind to see beyond that, whether it was because of love or a mental issue.
Okay.
She said, this is why.
So we said that what's the problem when you have a mental illness? It attacks which element? It goes to which element?
Your own thinking.
Yeah, which is which element in the existence of a contract?
It's capability, so therefore it would
Capacity. And if there is a limited capacity because you don't what? You don't understand what you are getting into. How is that going to affect the contract? The existence is going to be affected under which element now? If you don't understand, what would be the problem with your contract? We said for the contract to exist, you have to have an agreement, intention to create legally binding relationships, and consideration. Which one of those three elements is going to be affected if you have limited mental capacity?
Cognitive, all three.
All three? So we start from the top. Which one is going to be first affected? Agreement. So this limited capacity
You don't know what you're agreeing to.
is going to mean that there is no agreement. So you would have the election of voiding the contract, saying that the contract is voidable. Does that make sense to you? Because you're saying it doesn't matter whether he's mentally ill or not. Do you think that if he were mentally ill, that would affect his understanding of what he was doing in terms of selling her or gifting her the house, if we take it that way? So you reckon that makes sense? Okay, all right. Yes?
Can I make a suggestion to muddy the waters? What if they actually used to be married, then Luke divorced Dipros, and then Dipros still loved Luke?
Okay. So someone is saying, does it make any difference if this was after a marriage that ended in divorce, but the husband can't let go? So the children are, let's say, his children, or from out of, okay. Let's say that the children are from both of them. One is hers and the other is theirs. Or what am I talking about? Let's assume that their children are from Dipros. They had 2 children together in marriage, and then they got divorced. And then Dipros doesn't want to let go. He still loves her, and he loves his children, of course. So she sells him this story. He ends up buying the house for them. What do you think now? Does that change anything?
Well, it could also be considered a gift for the children instead of for her. So it would mean that that would probably make things a little bit more different, because still
One step at a time, so that we don't actually muddy the waters, as you said. Let's just throw in one fact at a time. There was marriage, they got divorced, the children are his children, and the rest happens the same way.
Oh,
What would change now?
a statutory duty.
Okay. So someone is saying now you have a duty to do what?
Duty of care.
Duty of care to do what?
Take care of the children.
Okay.
If they-
So we're talking about family law, and then you would have a statute duty on you to take care of the children. Great.
to pay child support for a few years.
But let me go back to this scenario. She lied. So they were actually living in a home, maybe not owned by you, by Dipros, okay? It's not owned by you. They're living in the home, your ex-wife with your 2 children. And then you're still in love with her, so you keep actually this contact. So she decides to use that to her advantage. Let's keep that there. And say that she lied to you and said that we are going to be evicted from this home, which you don't own. So they're renting out maybe. Okay? And that resulted in you buying the house, not just only buying the house, but also buying the house and putting it in her own name. Yes?
Can we not assume that because he loves her, he would also love his kids equally, so he probably is already paying child support to keep them,
Okay.
whatever their requirement was to him to pay.
Is that a reasonable expectation?
Yeah.
Is that a legal expectation?
Why? You would,
As they said, it's a duty.
yeah.
Okay.
duty of care.
But let's assume all of that's happening. And on top of all of that, this happened. Then what?
The mother may not be using that money adequately, and that's why she might be getting thrown out of the house.
So again, would there be, so this is my question, they were married, they got divorced, the children are his children, and then the rest is the same. Do you still think that the court would find that there was unconscionable conduct in the situation? I.e., because the issue here is what? The special disadvantage. What do you think?
If he was already meeting all the requirements necessary, and he went above and beyond, it was a lie.
Okay, so does that change anything? All of what we just talked about in terms of marriage?
It doesn't really change anything, because she still led him to believe that she was in a crisis situation, and she still manipulated his emotions and feelings and stuff.
Anyone wants to this? Yeah, does someone who disagrees? Yes?
I think like there must be like an element of trust there. Like he would obviously have to trust that she would do well with like her children.
So someone is saying there has to be an element of trust because of the children?
Yeah, like he isn't gonna give girls money away.
So what does that tell us? If there is that element of trust, you're saying there's now this element of trust because of all that we talked about, the marriage and the divorce and the 2 children, that created an element of trust. Okay? How is that now going to now change this idea of special disadvantage? Do you think that Dipros is now not under a special disadvantage?
Wait, do they still have a mental disability? Or?
So let's take that out. No mental disability.
If he's still under trust,
What's one at a time, please?
He's like silly for being manipulated by it, but obviously his intention is right. Like he's like, I want to protect my family. So he was like, well, I trust her that he's gonna.
Was he under a special disadvantage? This is what, folks.
because it was trust. That trust is the disadvantage. You don't actually know.
What if he developed the trust under the disadvantage?
It's still trust.
The trust will be null and void.
Folks, when we look at legal analysis, it has to always go through the elements. Did I change the elements for this theory? But I changed the facts. How did the facts change the issue? Because it's always when you superimpose the facts on the issues, when you superimpose the facts on the elements, that you can see the issues. How does marriage and divorce and the 2 children being his children change the issue here? The elements will not change. So the way we go through it, and let's do it, because probably that's the best preparation for that part B. Let's just wait and do a few things here, and then we'll go to the next one. So these are the elements. We're talking divorce, we're talking marriage, we're talking divorce, and the 2 children, his children. They were in a position of special disadvantage. Dipros, so when you write Dipros, was in a special, in a position of a special disadvantage at the time of the contract. The contract here is what? The house. Okay. I want someone to pick up on that, but later on. So, is there any issue here based on the facts? I.e., on the facts, marriage, divorce, children, house, this infatuation, and giving her the house in her own name. Is there a special disadvantage still? Because we know previously that there was. If I throw in the marriage and the children, does that change that? Someone says yes. How is it going to change that?
Well, I think if you're not, like, you have to look after them. So any parent is going to obviously try and provide. So it's not a disadvantage. It's just like their duty. Like that's.
But is that the source of the disadvantage? The source, as we said, was this infatuation. Dipros is infatuated with Luth. Now the question is that infatuation going to be changed or varied if we say that they were married and then they just don't give me no, because that's not going to give you a good mark in the exam or anywhere, or even in a board of directors or executives. Always argue the facts, not yes or no. So you're telling me if I say that they were divorced and then they married and then divorced and they had 2 children, his love and infatuation would pretty much not change. Why do you think he wants to give her the home? Really? In the real case, he wants what? Why is he giving her? So he's infatuated with her. Now we're going back to the original. The kids are not. So I gave you her love. And I gave you her love with 2 children. Do you think that the infatuation is going to vary or it's going to still be the same? And if that's the case, how would you then say that it doesn't change given that they are divorced? What does it tell you when I say that? So you have to imagine now. If I say they were divorced, who signed the divorce papers? Dipros? If he's infatuated, why would he sign the divorce papers? Why wouldn't he try to make it work? Which is not on the facts. So we're not on the fact. But that's where I want you to go with that. You see, pick up on the fact and say that infatuation. So this could be part A and part B of an exam question, right? So we could start with this scenario, just like Luth and Dipros. Everybody's going to score full marks because you're just going to copy from the textbook. But in part B, I will vary that and say, how is that now going to affect what you have up there? And that's where you want to give me that kind of thought. You know, the idea that if you're talking about divorce, you know, is that still the same infatuation where it's... So that's why I say in the US, people study law as a JD. You are already 23, 25 years old. You have life experience. You have been maybe through a divorce. At least someone have stolen some money from you because of love. So you know what's going on in life. But if it's not there, it's hard for me to transfer it to you. This is real life, yeah? This is real life. You have to talk from something you have experienced yourself or you know someone who did.
You could have become re-infatuated, like you fell out of love with her and then fell back in love with her.
Okay, yeah. But again, folks, you know, arguments are not created equal. Some arguments will convince a judge or convince someone to give you something or convince someone not to do something. And that's what I'm looking for. Stronger arguments, yes?
If he really loved her and she turned to him and said, I will be happy with someone else or without you, if he truly loved her, then he would probably let her go and say, I want you to be happy rather than be unhappy with me, no matter how much it hurt him. Like putting
Okay, and then what? And then what? Why?
Because he wants her to be happy and live a
No,
nice
but
life.
the scenario that we see in the real life, folks, the scenario in the case is telling us what? He's bothering her. So it's almost kind of, you want to go and get some sort of an order, restraining order against him. He's always, you know, back in...
He doesn't say that he's bothering him.
No, but...
She came to him and told him.
Yeah. Why? That's my point. Why do you think this happened in the case? Why would a woman who doesn't love you, okay, not tell you to your face, I don't love you, but go through this route and say this? What is she trying to do?
She abused his emotions then why?
Yeah, because...
Because she knew that she would get something out of it.
Yeah. So how is that going to change if they were married and divorced and then you said, I would love you to go and live with someone else and, you know, whatever? And then what are you going to do? You're still gonna be after her trying to do this, and then she's gonna still try to get you out of the loop by trying to get you something you wouldn't actually do for her. She thought, I think, that's what I think. I thought he would never do this. I thought he would never do this. That's why she asked this of him. I thought that she was giving him some sort of a impossible demand so that you go away. That's how I see it.
She thought wrong.
Yeah, but that's where she was going with that. I keep spitting because I'm talking too loud, but she is trying to do this in order for her to get rid of him. And because maybe for mental illness or whatever, that's how I read this case, he still decided to go with it. But again, she did not get the house at the end. Now this is the question I want to go back to. Why? Why do you think this case was decided as a contract? We were saying here that this was a house that he put in her name. When I put a house in your name, I want to put a house in your name, okay? I just changed the house ownership, give it to you. Is that a contract? No. What is happening here? Why did they decide this was a contract? Yes?
Because he gave her money to buy a house in her name, but he gave her money on the promise that she would buy that house in her name. He didn't actually buy
Yeah, so he gifted the money.
Is it too large for you to get?
Okay, we're going somewhere now. So, someone is saying, if this was a diamond ring, maybe something we're talking about like, I don't know, $5,000, $2,000, do you think that this would still have been the same judgment? That the court would still have said, oh, this is definitely unconscionable conduct? Okay, number one. Number two, still, why do you think they found a contract in this case? Not just because it's too expensive, it's something that you wouldn't buy every day, but what else? So someone is saying there was an agreement in terms of an offer and acceptance. What do you think that agreement was? I would give you the house, this is my promise. What is your promise? What am I buying the house with? What are you buying the house with? What does he want? Love. No, yeah. I will buy you the house. There has to be an agreement. Where's the contract? Where's the contract? It's not a gift. It doesn't matter. Where is the contract? It's not a gift. There has to be a promise and a consideration, something you bought it with. I will give you the house. Yeah, what do you want? I want your love. So that's when we start talking about this marriage, divorce, the children. How could that still be working between such people after going through that process? Okay. This is very early on in the relationship. I don't think it could be rekindled that way after.
At the top stage, the pros fell in love with him. Where there's obviously is that they met each other. He fell in love with her. So obviously they didn't have any pre.
No, I know that. So someone's saying there is no previous relationship. I understand, and that's why it was very exciting to suggest that. What if there was? What if actually they were married and divorced? Would that still be an infatuation like that? So this is where you need to go through with this. So, folks, all I'm saying is that law could be fun. Okay, it's something that you might actually fall in love with love. So it's something that you can actually become hooked to doing, not necessarily as a lawyer, but when you sit around the dinner table, don't tell people I told you that, and you say the same thing to your parents and siblings and everyone on the table, because now they're going to see someone who doesn't just simply agree, someone who's actually always, as you said, playing the devil's advocate. That's what you want to take out of this, not necessarily becoming a lawyer. Okay, let's move on, please.
Can I just ask?
Yes.
To get to the High Court, are we saying the house is over like $750,000 or something?
So someone is asking about the price of the house by the time they got to the court. Yeah.
Yeah, because I look up the intermediate courts, it's up to, say, Queensland, $750,000. But if she's now appealing the decision.
No, that is the first instance court.
Okay.
So the list that you see on page, what's the page?
52.
Page 52, it talks about certain limits. That's not the end of the process, that's the beginning of the process, where you start from. If you decide on a point of law to appeal, then of course that doesn't matter anymore. It's going to go up because it's someone who's up there who has to decide it, even if it was a lower value house. Yes?
Yeah.
Okay. So let's switch gear and go to chapter 13, please. 332, page 332. And let's look at Yango Pastoral Company Proprietary Limited and First Chicago Australia Limited from 1978. Okay, this one. So we're talking about illegality here, yeah? Okay. So, First Chicago, Australia, back in 1978, I don't think there's such a bank anymore, made a loan to Yango Pastoral. Okay, again the loan must be secured. So it's secured by a mortgage and a number of personal guarantees. Subsequently, Yango defaulted. So the bank, First Chicago, sued. What do you want? The mortgage and the guarantees. At the time, we had a banking act that prohibited a body corporate from carrying on the business of banking, so that's Chicago, unless it held a banking license. The act provided a fine for each day of breach. So when the matter was first heard in New South Wales by the Supreme Court, it was agreed that First Chicago was, at the time it made the loan, carrying acts or carrying business, carrying on business of banking contrary to the prohibition in the act. So it means what? They don't have the required license. So what does that tell you already? We have an act, so this is illegal, and Lewis is smiling. So this is illegal by what? It's illegal by statute. The statute is the Banking Act. But is it illegal by being formed or by being performed?
Well, it was the thing is that First Chicago was previously, performing banking acts, despite not having the license to be able to work under the banking act.
Sorry, when you say at the time it made the loan, means what? At the time the contract was entered into. That's what I'm talking about. Is this contract, which is illegal, is it illegal as formed?
It's illegal as formed.
Thank you. Because
Because it was
from the very beginning, they didn't have the license. It's not like it's expired or something. Yes? Okay, let's look at the issue. And this is the one you really need to start getting a sense of how you use it in the exam, how to identify the issues. It says, could Yango Pastoral and the holders of the personal guarantees successfully argue that the mortgage and the guarantees were rendered illegal? And if they are illegal, they would be void. So they found out this fact that these people actually, when they entered into this agreement, this contract, didn't have the required license to do so. So can we now then go and argue that this was an illegally formed contract? If it's an illegally formed contract, it has to be void. What did they say? No, they're enforceable. How are they going to do that? So the counter counsel, the counsel for the bank, of course, are going to be very, very good because they were able to come out on top and say, yes, it's still enforceable. We just said that they didn't have the license. We just said it's formed as illegal as formed. Yes.
But the same issue with that there is that I can get a loan from somebody. I can get a loan from my parents to get a house. Of course, they're not that rich, but like I can still get that loan. So that technically means that they're kind of performing an act as a bank type thing. Right?
The mortgage or the loan? You're getting the loan or the mortgage from your parents?
A mortgage is a home loan. Last time I
No, but I want to see whether there's a bank involved. Are they giving a collateral to the bank, and the bank is going to give you the money?
There is no bank.
No bank. So what kind of contract are we talking about? If there's no contract, if there's no bank, and you are making this thing you call agreement or contract with your parents, what kind of a contract is that? Someone's nodding. What's the problem now in terms of the first three elements? We said you have to have agreement, intention to create legal relationships, and consideration. Where is your issue now? He got a loan from his parents. Yes. So if it's now a social arrangement, what's the problem? There's a presumption that says what? That this is in fact not a contract, and you have to rebut that. Come on. Go back and revise.
The movie's on Saturday and you didn't turn up. I can't see you. It's breach of contract.
So how can you change that? How can you change?
It was based on triviality.
No, it's the social agreement. How can you change that between you and your parents? If your parents actually promise you, now let's just talk business. Your parents say, I want to give you the house. Are you going to say, hoo, I'm so happy, and you leave it there?
No, you have to offer something to them because you have to offer your consideration. So your consideration would most likely be something your parents can't.
Maybe it's a gift. And then you're happy, and you're going to leave it there, and then they die, and what?
And then the house is still in their name if you have an offer.
And you have siblings and all of that. And there's a will. So how do you walk around that? The point is that you have to make sure that you make it into a business arrangement. You throw in legal advice. You make it into writing. You create a deed. Okay? That would then say to the court, if someone comes and says, no, I disagree with this agreement, to say, no, it was intended to be enforced by the courts. This is actually a business agreement. Okay? All right. Shall we move on? So, they said it's enforceable. How? The object of the statute, they went back and looked at the purpose. So the statute interpretation was to prevent unlicensed bankers from operating without necessary authority. What was being prohibited was the manner, okay, or performance of the business rather than the provision of loans. How do you look? So What do you think of this reasoning? So it's not necessary that you agree, yeah? So in the comment it says, in this case, the object of the legislation was to prevent banking being carried out without the necessary authority, and this was to be achieved through the imposition of fines. So our reflection is on what basis the loan would be found illegal. Let's have the discussion together, folks. What do you think? Because you're talking and I can hear you talking, and I know that you're talking about the case, and I know you're a genius. You are just going to give me an answer right now why this was the case here. Why were these enforceable? Do you agree with this reasoning? How can you attack this reasoning? The court is saying the objective of the act is not the license. The objective of the act is how these banks behave. So, if they misbehave, there are fines. We can just slap them with fines. What does that, do you accept this argument? Yes?
Well, I think the basis that would make the loans illegal is if they charge them a ridiculous interest rate, like 50% interest, or if they agreed that the loan could be made on the basis that they would buy them drugs or something stupid like that, there where it would be an issue of fault. So that's when the loan agreement would be
So again,
legal.
do you think that if I want to go and give someone a loan without having the license to do so, would that be a legal loan? Here they're saying yes. Forget about the license. License. Forget about the license. All you need is that to make sure that you behaved properly. Do you agree with this reasoning? What's wrong with this reasoning?
No license.
No license? Yeah, so what? Is that an important thing, the license?
Yeah.
Yeah, you can drive without the license? Is that an important thing? Doesn't matter. As long as you are driving at the speed limit, why would you need the license? Forget about the license. If someone catches you, we'll just slap you with a fine. Hey, and it's done.
But there's certain ways around a license. Like you can ride a moped without having a motorbike license. Yeah, it's classed as a motorbike.
No, let's keep it simple. I'm saying you'd require the license, you require the license, but you don't have the license, and they're saying it's fine. Because we can always...
Is it because they acted fairly?
Uh-huh.
Without the license?
Uh-huh.
And the license?
And is that enough?
It sounds like it.
So what do you think? I'm asking you, what do you think? I know what they said. I'm asking you, what do you think?
It sounds like the fairness that they provided was enough.
So do you agree? Do you agree that it's okay for a bank to function, i.e. give loans without a license, as long as the court is satisfied they haven't done anything wrong?
If the conditions are fair.
If the conditions are fair. What about the silent majority? The silent majority, you don't want to say anything? Right or wrong? Because you're talking, I can see that you like to talk, but you're not going to talk to me. Okay.
I suppose the argument is, would Yango Pastoral have actually, you know, if their business was doing well, would they have complained about the bank not having a license even if they knew it?
Aha. So someone is saying this big fuss is not about the license. This is because the party who took the loan defaulted. Had there been no default, were they able to pay back the loan, you know, the license issue wouldn't come up, and everybody's happy. Is that enough for you to think that the license is not required?
So I think it's still required, but we're only putting simple.
Okay, but if the act is telling you, so this is my argument, if the act is telling you that you need a license to operate, it's very clear, right? This banking act is saying prohibited a body, corporate, i.e. First Chicago, from carrying on the business of banking unless it held a banking license. And the bank and the act provide the fine for each day of breach. So they're saying, as long as First Chicago is willing and will pay the fines, then nothing is illegal. And they can still pick up the mortgage and the guarantees, the personal guarantees. So we can disagree. I think this is rubbish. I think this is not a good, at least the way we're looking at it here, because if you go back and read the actual reported case, you might pick up other facts that change your mind. I haven't done that, so I don't know. But I'm saying on this, it doesn't make sense to me. Just like that love thing, the unrequited love with Luth.
Too emotional, where you sort of feel like something is wrong with the cause.
No, but I'm saying sometimes, and that's what, if you end up, for example, becoming a jurist, which is not a lawyer, right? A jurist, someone who studies the law, that's what you would write a paper on.
Emotions cloud your judgment.
Yeah, but that's what you would write a paper on. You would go and critique a decision by the Supreme Court, or critique a decision by the High Court, or the European Court of Justice, or whatever. So, not necessarily that you agree all the time. Okay, and sometimes there would be tension between different judgments, so you have to reconcile, and so on and so forth. We don't have to worry about that. Let's look at 334. We'll have this to be the last one today, and then we'll have a break, and then a quick tutorial. Yeah? Oh, Bill, what? You don't want the tutorial, Bill? It's going to be very quick. Just 2 questions.
What's the tutorial?
This was the tutorial. This is the colloquy, because I'm trying to get people to talk to me. I will keep trying to get them to talk to me. High Court of Australia, 1915. Wilkinson and Osborne. Wilkinson was acting as an agent. We'll look at agency in week 10. For the owners of a large property which had been offered for sale to the government. Okay? Anxious to get his commission, that's the agent, Wilkinson approached Osborne and Jones, who were members of the Legislative Assembly, the government, to use their influence to get the government, okay, this is the bit we want, to use their influence to get the government to close the deal as quickly as possible. What's wrong with that? Do you need a license for this? What do we call this, by the way? In the US? Yes. But do you know of people who provide the service for a living? Yes. And in the US they call them, starts with an L, lobbyists. Thank you. That's what lobbyists do. Keep that in mind. Okay? In this case, the agent went to these 2 members of the Legislative Assembly, so members of Parliament, and said, use your influence. He gave them a fee. Once there's a fee, you know that there is a contract. That's the contract, the lobbying contract, like. After the sale was made, great. Wilkinson now, why would you, so it's only 250 back in 1915 in pounds. Anyway, Wilkinson now refused to pay the fee. If Wilkinson paid the fee, we wouldn't be reading this. There wouldn't be a problem. No one would be talking about legal or illegal contracts, right? But for whatever reason, Wilkinson decided not to pay. Okay, so these 2 members of Parliament sued for the fee. They sued for the fee. The decision was the issuing of the notice based on a contract that was against public policy. What contract are they talking about? The sale contract of the land? The land sale? Yes?
Was lobbying actually illegal back then?
So I'm just asking the question first, and we'll go back to that. Which contract we're talking about?
Paying the money in order for somebody to push for something.
Okay, so this is the lobbying contract, if you want to call it that. It's not the land sale, the lobbying contract. What is the public policy? Okay, let's continue. We'll come to that. So they said void and contrary to public policy. Why? The respondents had used their weight. These are members of Parliament. Okay? To advance their own business interests. Okay? So what was the problem here? Wilkinson or the members of Parliament? So what's the problem then with this kind of contract? When you lobby the government, who's your daddy? Where is the money coming from? From the government?
The money's coming from like different international agencies who have interests.
A foreign government, for example. We're not going to call names. A foreign government. They want something from Australia. They want something from Australia? Okay. I find Bill. Okay? I'm going to pay you, Bill, to be my lobbyist. So what are you going to do? You're going to go and set your tent there in Canberra and do what? Try to influence the government to do something for this foreign government. Are you going to pay the Australian government any money? No, because that would be bribery, unless you are in one other country which is not going to be named. Because that's business practice there. So, you are my lobbyist. I'm paying you. Is he paying the government? At least officially, no. You might pay their children. It's all right. Okay? Like that tax office thing. So, what is the problem here? The problem is that the payment went to these members of parliament, and that was against public policy. And you can see why. So they're saying lobbying is not necessarily a big problem as long as it's done in terms of trying to influence someone's decision. So you're trying to give them information. You're trying to explain to them the situation. You're trying to tell them about the options. You know? But if you start paying money, that's what they are squeaking about. £250. Okay? But I don't know. What do you think? What's your name?
Alex.
Alex.
I was just wondering, because I'm trying to think about it, I'm like, there's so many, like, grey areas where
Everything is grey. Have you heard of lobbyists in Washington, D.C., for example?
Lobbyists in Washington, D.C. I've heard absolutely terrible.
But have you heard of it as an industry or not? That's my point. Have you heard of brothels? That's my point. Do you know then that they are legal? That's my point. Is lobbying legal? Because you've heard about it. It's reported all the time. I mean, lobbying is not an issue.
You can't have a capitalist economy without corruption and lobbying.
No, it's not corruption. Lobbying is not corruption. You see, lobbying is pretty much someone arguing in your favor. Okay, so it's not necessarily It's not necessarily corruption. You know, I'm not saying that every lobbyist is corrupt. But how are you going to be able, so if there's, for example, a big company, okay, and the company is almost always winning contracts from the government. As a newcomer, you're going to be business, working in business environment. How are you going to convince them that this new kid on the block is able to provide the same service even better and for less? You need someone to lobby for you, not necessarily in a corrupt way. But you have to get the ear of these people. You have to make presentations to them. Compare. If there's a tender, for example, what you're doing in comparison to the other company. That's not illegal. That's not corrupt.
I'll just make a counter argument that doesn't that encourage monopolies by the ones who have the most money end up being able to spend the most and lobby the most and therefore get the most through, so you end up having.
So how would you answer this counter argument? The first thing you'd say is what?
Not always.
It depends. So you'd say yes and no, because it depends on whom you're lobbying with. If these people are monopolizing a certain sector of society, what you could do, a certain service of government, what you could do is to go and lobby other information providers, non-government organizations, people, for example, who are against certain policies. I can't think of something, but recently there's this issue with regards to welfare payments to people on drugs, and they want to experiment, I think in London City, at least two places in Australia, whether you would be able to get these people referred to doctors. So it's an experiment, okay? If you want to lobby against this, you wouldn't go lobby with the government. You would go lobby with the sort of a medical organization, a medical association. Okay, that's the kind of thing I'm telling you about. Even if there's a national monopoly, if there's a monopoly, and a national monopoly, of course, is something like, for example, an electricity provider or network provider, Telstra. But let's leave that. Let's talk about anyone who's a monopoly on contracts with government. You don't need to lobby the government per se. You can lobby others who can put pressure, like through media, that would get the government to think maybe we should bring some people in as well. There was a very interesting actually movie called War Dogs. War Dogs? You saw that movie, War Dogs? What was the sort of plot? It's a real story. It was about those two Jewish guys, one of them at least, and they were starting to take contracts from the Defense Department in the US to supply arms to the conflict in the Middle East. Why were such little fish able to get such contracts? Exactly because of this lobbying. Not with the government. You can't go and lobby the Pentagon. They lobbied outside, so that they put pressure on the Pentagon, so that the Congress came in and said, why are you always awarding these contracts to the same companies? So they started opening up, and because of actually that, they ended up going to jail, these two guys, and then, of course, everything changed again.
Is it to do with something to do with like the US-Israel alliance type thing?
No.
Okay. Sorry, just everything in the Middle East is just...
That's the easiest way you can answer an argument. No. It depends. I'm not sure what you're talking about, me. All I'm saying is that there's a movie that talks about such things in relation to lobbying and how governments change their position based on lobbying, all right? So, a comment, yes, we're almost going to finish now. A comment, this is the last thing. A comment that interferes with the impartial judgment of public officials, including members of parliament, is illegal. Okay, that's what they wanted. Okay, so let's then leave it for now. Let's go back. Let's have a break for 5 minutes. Come back at 3, and I promise we're going to be finished by 3:30. How's that? Yeah? Thanks.